The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We are happy to have you with us today. We are hearing 3 cases, and we can start with our first, number 25-1050. And Mr. Parsley, we will hear from you when you're ready.
May it please the court, Robert Parsley with Bradley for the appellants, the Stokes and GSH of Alabama. This appeal is about personal jurisdiction. The appellants filed a third-party complaint against Westerfeld Construction, which is a Florida company. The district court dismissed the claims against Westerfeld for lack of personal jurisdiction. This court should reverse and remand for further proceedings. We have 3 main arguments for reversing the district court. First is, excuse me, the appellants have alleged a plausible common plan that constitutes a conspiracy with a South Carolina company.
Can I ask you a question about your conspiracy theory of
Yes, Your
personal
Honor.
jurisdiction? So this is the theory, and we've adopted it in cases like unspam, where you impute the contacts of mobilization funding to the defendant. And we have cases on that. There's a whole 3-part standard. Was any of that briefed in front of the district court?
It was, Your Honor.
How so? Like, did
Well-
you actually set out, here's the 3-part standard, here's the cases? Because I couldn't even find the word impute anywhere.
The conspiracy argument was made in the briefs of the appellants.
What do you mean when you say the conspiracy argument?
Well, they argued that there was a conspiracy among the lender and Westerfeld Construction. There is not citation to unspam or other cases like that.
Or the standards, or the
No, Your Honor.
argument that the contact should be imputed?
No, there's not, Your Honor.
Okay.
But a waiver argument has not been made. So I think that will be a waiver of the waiver.
I'm
And,
sorry, please, yeah.
and the other point is the district court did conclude that a conspiracy had not been alleged. So I think we're safe to make that argument. But there
So
are
on that front, can I
Yes,
ask you
Your
on the
Honor.
merits?
Yes.
This case strikes me as fairly similar to Twombly. I assume you know what case Twombly is. Good.
Yes.
Okay, so I know Twombly's a case about 12b6, and this is a case about 12b2. But when I read the Supreme Court's decision in Twombly, and when they explain what's wrong with the complaint in Twombly on the merits, they say, like, just because you say the word conspiracy over and over and over again, as the complaint in Twombly did, doesn't mean you've plausibly alleged there's actually a conspiracy. And when I read the complaint in this case, I have a sort of the same feeling, like, just because you keep saying the word conspiracy again and again and again doesn't mean you've plausibly alleged the existence of a conspiracy. So could you identify the best allegations in the complaint, like through this Twombly lens? Does the complaint plausibly allege the existence of a conspiracy beyond the places where the complaint just says the word conspiracy? Where does the complaint allege facts that you think make it plausible there is a conspiracy?
Good question, Your Honor. We set those out in our brief, both our opening brief, our reply brief. I'll kind of go through those
Great.
key facts.
Okay.
In general, the common...
But see, again, this is what Twombly says we can't do. We can't say in general. I need to know what paragraph of the complaint we're talking about.
Yes, Your Honor, I'll be happy to do
Okay.
that. I was just going to
Okay,
summarize
sure, okay,
the nature
sure.
of the nature of the common plan, which is that these parties induced the Stokes to enter into a joint venture on this Florida construction project to guarantee a construction-related loan for that project with very unfavorable terms, with the representation that proceeds from the owner that would be paid for that work would go in part to pay down the loan as well as to pay for expenses and wages. That the money was not used for that purpose. The money was used both for the benefit of Westerfeld and the lender for other purposes. In fact, the appellants were left with some unpaid expenses, and that they seek to protect, the lender seeks to
Right,
protect itself through these
I'm still not
releases.
hearing references to paragraphs of complaints that allege things.
I'm getting to that, Your Honor.
Can you show us in the, or tell us in the JA exactly in the complaint where, give me a JA site where
Yeah.
this is alleged?
So Joint Appendix 175 and 176 provide very specific factual allegations of this relationship, which included a referral payment to Westerfeld. It says that they made false representations to the Stokes to induce them to enter into this agreement. And those representations are set out in detail at Joint Appendix 205, 206,
This may be a
207.
different section of the complaint, but there's a section of the complaint, or if you're referring to this one, where we say, like, there's the CEO of this one company and the CEO of this one company, and they were both working together, and between them, they said the following things. But it doesn't tell me who said what. It just literally says one of these two people said each of the following things.
That's right, Your Honor.
But isn't that, like, really important to know which of these two people said these things?
Well, I think the allegation is that both of them, both Mr. Pepper and Mr.
Were in a
Banks
conspiracy together.
were together making these misrepresentations to the Stokes. And we know very
so-
specifically what those misrepresentations
So let me give you a
are.
hypo that captures what I think is basically the problem. Say, I have an apartment, and say I'm a renter, and I enter into a direct deposit agreement with my landlord that allows them to take money out of my account to pay my rent. And then I need to sign up for Power, and I live in Virginia, which means I basically have to use Dominion. So I sign up with Dominion, and Dominion can also auto-debit my account to pay for my rent. And the allegation is that both of them take more money than they're allowed to take, right? I mean, that might be bad on one or both of their parts, but that doesn't prove the two of them are in a conspiracy. It just proves that the two of them are both ripping me off, maybe. So what in this complaint alleges something that moves me from maybe both of them are taking advantage of your client to they're both taking advantage of your client pursuant to a common scheme or plan sufficient to allow us to impute one of their conduct to the other? Where is that in the complaint?
Right. So in the joint appendix, pages 416 and 419 are documents that govern the disbursement of funds.
These are the
And-
documents to which one of them is a party and the other one is not?
Correct.
And the one that's not a party to these agreements is the one you're trying to get personal jurisdiction over?
The one that's not a party to the second agreement, which
Okay.
is Westerfeld. But Westerfeld had the power under the Florida contracts that the payments from the state of Florida came to Westerfeld. It had custody of those payments. It then used those payments, initially placed them in a joint account between the lender and the joint venturer with the Stokes. Later, a funds control agreement was entered into between the lender and Jessup, which gave Westerfeld the ability to place those funds in an account jointly held by Westerfeld and Jessup. And so Westerfeld had the power to disperse funds, to choose where those funds would go. And then it could choose to place some of those funds into a joint account between the lender and Jessup. That shows that Westerfeld was cooperating with the lender to determine where the funds were going to go. And in
But
fact,
isn't- but
Westerfeld had
but
to have the consent.
Westerfield
Yes,
is
Your
the
Honor.
general contractor, so that's, that's kind of the role of Westerfield as a general contractor, right?
Right, but it flowed into the loan. The contractor was placing these funds in an account that the lender had control of for purposes of the construction loan. okay? And that was contemplated by both of these agreements I've referenced. And the allegations in the complaint are very specific, that both the lender and Westerfeld diverted these funds for their own purposes, not to pay down the loan. They didn't pay down $1 of the loan.
Can I ask you a slightly different question? Under our conspiracy jurisdictional theory cases, you have to plausibly allege the conspiracy, but you also have to allege what you're imputing, if you have plausibly alleged a conspiracy, is you're imputing to the defendant mobilization funding's purposeful contacts with South Carolina in furtherance of the conspiracy. And is there somewhere in the complaint where you allege, like, I actually don't know, what is mobilization funding doing in South Carolina in furtherance of the conspiracy?
Mobilization funding, the lender, is South Carolina company. It's receiving the funds.
But you don't allege that they incorporated in South Carolina sort of in furtherance of the conspiracy. South Carolina has law that's going to facilitate the conspiracy.
No, they weren't.
So that's
The
out.
company wasn't formed pursuant to the conspiracy, although the company was acting to induce the Stokes to guarantee the loan, to have payments from the
They met
Florida.
Stokes in South Carolina to do that. I'm really trying, your complaint, I think this goes back to the fact that you didn't actually argue this theory in the district court. The complaint is kind of short on details about where mobilization funding was doing certain things.
Mobilization funding was always acting in South Carolina. It's where its office is. It's where it's incorporated as an
Isn't it
entity. It's where
headquartered?
its
Where is it
president
headquartered?
is.
Where is it headquartered?
Beaufort, I believe, is the name of the town. Beaufort. Sorry, I'm from Tennessee. But mobilization funding was receiving the payments from the Florida contract through Westerfeld and using it for its own purposes.
But they were, okay, but as I understand, the way the money goes, it goes from the state of Florida to Westerfeld,
Yes.
and the bank account that money gets dumped into is in Florida.
Right, but it's a joint bank account.
But it's in Florida.
It's in Florida, yes,
Okay,
Your
it's
Honor.
not a South Carolina bank account. Okay. And so then the allegation is that Westerfeld's asserted co-conspirator then pulls money out of that, and the co-conspirators in South Carolina, that's the theory?
Well, yes. I mean, the Westerfeld is cooperating with the South Carolina entity to use these funds for improper purposes. One difference between this case and a lot of the cases where they said conspiracy had not been alleged is here the co-conspirator is a citizen of the state of South Carolina. Everything it does is in South Carolina. There's general personal jurisdiction over the co-conspirator, the lender.
Sure, but we've never said that that can get you general personal jurisdiction over, like,
No.
say I and a person who lives in Maryland enter into a criminal conspiracy.
Yes.
And let's say that, but all of the activities in furtherance of that conspiracy take place in Virginia, and I live in Virginia. You can't sue me in Maryland just because I'm in a conspiracy with a person who themselves is subject to general personal jurisdiction, or at least I'm not aware of any case that says you
All of the lender's conduct occurred in South Carolina.
Okay, but you don't disagree that simply because someone is a co-conspirator of another person who is subject to general jurisdiction in another state, that the co-conspirator then necessarily also becomes subject to personal jurisdiction?
No, it would be
merely the existence of a conspiracy.
No, it would be specific jurisdiction
Okay.
for the party by virtue of the conspiracy. But right, you impute the contacts
Right.
of your co-conspirator.
When you
Here,
impute the contacts that were taken in furtherance of the conspiracy, not every single contact they
and
have.
those, and here, that conduct occurred in South
Okay.
Carolina.
Thank
The other parts of the complaint, I think in particular, pages 175 and 176, 203 to 205, and page 214 of the joint appendix have very specific allegations concerning this joint conspiracy. I will allow Mr. Bible to thank you.
May it please the court, I'm Mark Bible and I represent Westerfeld Construction by Glick. For simplicity's sake, I prefer to refer to Westerfeld as just Westerfeld, and the appellants as either the appellants or the GSH parties. First and foremost, I'd like to thank the panel for this opportunity. To start off, I'd like to address a few points that my colleague made in his opening arguments. Essentially, when asked whether the contacts that mobilization funding participated in were in South Carolina, my colleague indicated that they all were conducted in South Carolina, but that is actually far from the truth. In actuality, what happened was that Scott Pieper, a principal CEO of mobilization funding, who is a resident of the state of Florida, would communicate with the several parties via the internet and via email. And in that process, there were communications where Mr. Pieper introduced the GSH parties to my client for the purposes of potentially using the GSH parties as a subcontractor in the Rebuild Florida project, a project that was wholly performed in the state of Florida, and that the money for that project came solely from the state of Florida. And I'd like to also mention that when the money got paid to Westerfeld related to Jessup Construction's performance of work on that project, that money got placed into a bank account. That bank account was with Valley National Bank. Valley National Bank does not maintain any offices or branches in South Carolina. There were several states, and I believe the appellee's brief mentions the location of those branches. However, the money was deposited in a Valley National Bank account, and at that point, the loan documents that are a part of the record indicate that mobilization funding itself had the ability to debit the money out of that account and apply it to the loan. In fact, the funds control agreement that my colleague cited to in Joint Appendix 416 to 419 even says at the second page that mobilization funding may apply the funds that enter into the account to the loan principal and or interest. And in fact, the loan documents, specifically the loan agreement, indicates that same exact authority. All of these documents, importantly, were the subject of review before the GSH parties, the Jessup parties, and or the mobilization funding parties executed these documents. And I mention that importantly because there are a plethora of broad allegations, not specific allegations in the complaint, that indicate that my client induced the GSH parties into personally guaranteeing the note with mobilization funding. Well, they are self-proclaimed sophisticated parties in their complaint. They indicate that they are industry leaders for this type of disaster relief work. They were presented with the loan documents before they had to sign them. They had every opportunity to consult with parties to determine whether or not execution of a personal guarantee of $5.8 million was going to be a feasible solution for them. In fact, the only pleading that I'm aware of that the appellants expressly attribute to something that was said by Westerfeld was that the GSH parties may be entitled to receive $3 million for its performance of work on the Rebuild Florida project. Well, in fact, they say that they promised a $3 million payment, but in fact, the pleadings say they may be entitled to a $3 million payment. But that necessarily implies that GSH properly performed on the project, did all of its work in a timely manner. And in fact, that is not what we have here today. Unfortunately, there are no, in my estimation, Fourth Circuit decisions that expressly reference the facts that we are here to bear. However, many courts have found, specifically in McLaughlin versus McPhail, in Unspam Technologies versus Chernuk, that the appellant, in this case, must make a plausible claim that a conspiracy existed, that Westerfeld Construction participated in that conspiracy, and that mobilization funding's actions in furtherance of that conspiracy had significant or had sufficient contacts with the state of South Carolina such that they could subject Westerfeld Construction by Glick to jurisdiction in the state. And in this case, again, the pleadings that are cited by mobilization funding are just bare allegations, and that is what the district court found, and that is what we have argued in our brief. They go to say, without telling us, again, who told the GSH parties this information, they just broadly allege that mobilization funding and Westerfeld collaborated with one another to induce them into entering into the loan documents, and specifically the personal guarantees. They indicate that mobilization funding collaborated with Westerfeld Construction to siphon funds from them, when in fact the loan documents that they executed give mobilization funding the very right that they complain about, without any action or involvement, without even the first dime of money coming from the state of Florida to any bank account. So I'd like to draw that distinction to this court. The other arguments that are presented by the appellant deal with whether or not jurisdictional discovery was.
Oh, before we move on, can I just ask you, I asked your colleague about whether this whole conspiracy theory of jurisdiction had been raised in the district court, and I understood him to say no, but you guys don't seem to mind. So do you have a view on that?
Yes, Your Honor. It was not, in fact, expressly raised in the district court pleadings. Unlike my colleague, I've had the benefit of participating in the lower court proceedings. What I understand that they have done is really just alleged a cause of action for conspiracy, but did not argue that when I filed the motion to dismiss on behalf of Westerfeld. They did take the position, of course, in the lower court pleadings, specifically in their reply to my memorandum in support, that they had alleged specific plausible facts. But again, when we replied to that, we indicated again that these are not specific facts. They are very broad allegations. We did not intend to waive any challenges to their now asserting a conspiracy theory of jurisdiction, but it was not articulated to the lower court, Your Honor.
But you, for example, did not say in your red brief, say this argument was totally waived or forfeited before the district court. That is nowhere in your red brief.
I did not, Your Honor. I did not. So the next argument that the appellants make in their brief was essentially that the court improperly denied jurisdictional discovery. In this case, of course, it's a prima facie standard, and the court has a plethora of avenues that it could use to determine whether the prima facie standard had been satisfied by the appellants. In this case, the appellants did not expressly raise that they wanted to conduct jurisdictional discovery. Their request for discovery is but a note in the conclusion paragraphs of each of their responsive briefs in the lower court, indicating that the court should allow discovery to continue. And it did not say that discovery should be focused on jurisdictional issues that are before the court. They did not raise that issue. They did not make a motion to have the court conduct or allow the conduct of jurisdictional discovery. And that's very.
Did your colleagues ever move to file an amended complaint to make more fulsome jurisdictional allegations?
They did not, Your Honor. In fact, the ongoings of the district court matter currently. They've amended their pleadings to assert direct causes of action against the principal of Westerfeld, and in fact have used the very same exact complaint that we're focusing on here today. They have not changed any of the factual allegations, so they have remained in place essentially for the better part of a year with the same facts that they've alleged in the amended complaint that you are considering before you. But again, I'd like to mention that the failure to make the motion for jurisdictional discovery is very similar to the case of McLaughlin versus McPhail, where that party did not, or that party did make a motion for jurisdictional discovery, but the court still denied that motion, which is evidence that the court has very broad discretion on whether or not to allow discovery. And when the courts have held, when the party opposing dismissal for personal jurisdiction reasons only alleges bare allegations or conclusory statements, courts have found that there's no need to conduct to subject the party seeking to be dismissed from this jurisdiction to the discovery process. The courts have gone on to say if the court believes that the jurisdictional discovery would be no more than a fishing expedition, then the court could properly deny that jurisdictional request. So we believe that the court did not abuse its discretion in denying jurisdictional discovery. Had the appellants asserted more specifics as to what Westerfeld Construction actually did in furtherance of any common scheme, I believe that the court should have allowed jurisdictional discovery, but based on the bare allegations of the complaint, that was unnecessary. Lastly, the appellants focus on a supplemental affidavit that my client furnished on behalf of Westerfeld Construction. In that affidavit, it essentially says that Westerfeld Construction did not consent to, or did not enter into any agreements through which it consented to jurisdiction in South Carolina. The appellants contend that that was raising a new issue rather than something that was properly before the court in the original memorandum in support of the motion to dismiss for lack of personal jurisdiction. However, I wanted to clarify that.
Can I just ask you about something that you said that has been rattling my brain? So after this appeal was filed, your friends on the other side have now tried to sue Westerfeld in the District of South Carolina again?
They've not sued Westerfeld. They've sued Brandon Bay, who is Westerfeld's only member and manager.
Okay, but not Westerfeld. Sorry,
Not Westerfeld.
I was running into a final judgment. I don't understand how the case of them versus Westerfeld can simultaneously be before us and before the district court.
I apologize if I misled you. That was not my intention. So, Your Honor, they just alleged the same exact complaints against Brandon Bay. To move on to the motion to strike, again, the point that I wanted to raise about the affidavit was it did not fundamentally change what was stated in Mr. Bay's original affidavit that was submitted in support of Westerfeld's motion to dismiss. It just merely clarified that of all the agreements, to the extent an agreement exists, not one of them that Westerfeld is a party of did Westerfeld consent to jurisdiction in the state of South Carolina. That is an issue that's well before the court in Westerfeld's motion to dismiss, because we're saying that the original affidavit of Mr. Bay indicated that there were no contacts with the state of South Carolina. Westerfeld doesn't do any business in the state of South Carolina. Westerfeld doesn't engage in long-term contacts with any resident of the state of South Carolina, and didn't enter into any agreements with a party with the state of South Carolina. We thought that it would be most accurate and truthful to supplement that affidavit to say that there is no contract in total where Westerfeld consented to jurisdiction. Now, the appellants argue in a way that the funds control agreement, and that's again Joint Appendix 416 to 419, imputes some third-party beneficiary theory on Westerfeld because it has an indemnity provision in it. The indemnity gives favor to Westerfeld in the event that Jessup or any party claiming by or through Jessup seeks to sue Westerfeld as a result of its participation in transferring funds out of a Westerfeld joint account into the Jessup account for payment. Ultimately, we contend that that indemnity provision doesn't provide Westerfeld anything more than what the Westerfeld and Jessup subcontract provide. There's express indemnity language in there that prevents or subjects Jessup to indemnify Westerfeld in the event of third-party claims brought by people exactly like this, GSH and the GSH parties, for non-payment or for some payment-related dispute. There's indemnity in the Jessup subcontract for that. So I would represent to the court that mobilization funding might have inserted that indemnity language into the funds control agreement, but my client did not participate in review or sign the funds control agreement. It's not a party to it, nor does it intend to invoke the indemnity provision of that agreement because my client already has indemnity built into the Jessup subcontract that would accomplish the same task. There was no benefits conferred. Lastly, and I will be circling back around on the jurisdiction issue, one of the allegations that's made by the appellants is that Westerfeld participated in a referral partnership program with mobilization funding. To allege this fact, what they have done was cited a link to mobilization funding's website. Mobilization's funding website takes you to a page that says we offer a referral partnership program. There is nowhere in that website that it refers to Westerfeld Construction. There is no evidence, whether specific pleadings or otherwise, that indicate that my client participated in any referral program or received any proceeds from mobilization funding. In fact, the parties have had the opportunity to participate in discovery up to this point in the lower court, and you would think if that existed, they would have supplemented the record with that relevant material, but that did not happen. Your Honors, again, I appreciate this opportunity, and I'll yield my time.
Thank you.
Thank you, Mr. Bible. I'd like to clear up just a few points. First, there is nothing in the joint appendix that says Mr. Pieper lives in Florida. Okay?
Is there anything that says he lives in South Carolina?
It just doesn't say where he
And
lives.
who's
It doesn't say.
But that's your problem.
Well, it's not, respectfully, because he's acting on behalf of mobilization funding, which is a South Carolina entity.
Where is its principal place of business?
I believe it's
I thought
in
it was in Florida.
Beaufort?
It's not in Florida?
No, it's in South Carolina,
No,
Beaufort.
I know it's incorporated, and I know there's an office in South Carolina, but you're saying it does, its principal
It
place of
doesn't,
business is
this,
South
the
Carolina.
record that is before the court on this appeal, I don't see where it says specifically where its principal place of business is. But the
you're
court,
the one who's trying to establish jurisdiction.
I mean, the court could take judicial notice of a later filing which shows that its principal place of business is in South Carolina.
I thought even in the complaint, let me see if I can find it. I thought that you even alleged that the principal place of business was in Tampa.
I don't, in which document?
In Tampa, that the principal place of business is in Tampa, Florida.
I don't recall that, Your Honor.
Give me. Keep
I
going.
can say that none of our briefing in this appeal makes any statement about where the principal place of business of mobilization funding is. So, the choice of law provision in the loan documents is crucial. Mobilization funding said, if we're going to litigate over this loan, we're going to do it in South Carolina. That is a crucial jurisdictional fact.
Well, it is, but again, I think you'd have to be alleging that that was done in furtherance of the conspiracy. Again, that the choice of law clause was in there to further the conspiracy.
Well, I think here, Your Honor, the liberal standard comes into play, and that is the court has, because this is a prima facie question, not a preponderance of the evidence,
So can I know what you mean.
right? You construe all this in the plaintiff's favor.
Well, yeah, can I ask you a question about that? So the Fourth Circuit has endorsed this conspiracy theory of jurisdiction, but some other courts haven't, and they pointed out that it's in pretty significant tension with all the times the Supreme Court has said, no, personal jurisdiction, it really has to be based on your own conduct, not somebody else's conduct. And it does strike me that given that tension, we'd probably want to apply this theory of conspiracy jurisdiction pretty strictly. You know, if we apply it too broadly, we really are running into this problem with all the times the Supreme Court has said, like, you really can't drag Westerfeld into court because somebody else drafted a contract and signed it.
I respectfully disagree, Your Honor. The conspiracy theory is binding law in this circuit.
It is, but
Walden,
Walden
did not.
Can I finish?
Yes, Your Honor. I'm sorry.
Are you aware of any cases where, there are cases where we've endorsed the theory, are you aware of any in which we've actually found that the standard is satisfied? Because it looks to me like we actually apply it pretty strictly.
In those cases, I mean, Doe v. Mast, which is in the brief, 741 F Sup 3rd 409 is an example where
we said,
no, it's not the Fourth Circuit, it's a district
okay,
court.
okay.
And Spring Industries, which is in the briefs, which is a district court case, and the BioCare case, which is another case, a district court case. All of those found there was jurisdiction. The difference between this case and Lolavar and Unspam, there are far, far more specific allegations of specific conduct in this case than in those cases. In those cases, like McLaughlin, they just said they conspired. There was conspiracy with no specific conduct identified, no common plan described. The complaint, it doesn't say it all in one place, but the complaint in this case very specifically alleges conduct, statements, collaboration.
Well, it seems like on the claim of inducement on your, I'm asking, like, what is your evidence of inducement? The only thing that it seems like you're citing is the terms of the agreement. So
No, that they wanted them, that the conspirators wanted the Stokes to guarantee this loan because they wanted to obtain the money from that project and use it for their own ends, perhaps to pay back their own loan, and that they were making false statements to the Stokes to induce them to make that guarantee. They later diverted funds for their own use. They kept the Stokes in the dark. They refused to share information with them. And then now they are relying on these very broad, onerous advance releases of liability in the loan documents to say, well, we kept your money and now we're going to sue you for loan default. That's the conspiracy. All of that is very specifically alleged in the complaint, including at the pages I mentioned.
Oh, and
One- I'm sorry.
back to
Yes,
Judge
Your Honor.
Harris's original question regarding the principal place of business. It's on JA 176, where you said that MF2 is a South Carolina limited liability company with its principal place of business in Tampa, Florida.
Okay. I'm sorry, Your Honor, I missed that, but it's a South Carolina company. There would be general personal jurisdiction over the lender in South Carolina. Walden should not change this court's application of binding precedent concerning conspiracy theory. If you look at Doe v. Mast, 741 F. Sep. 3rd, 409, it discusses this in detail, how Walden did not change the analysis, and that's correct. A conspiracy is the defendant's own conduct. You are looking at the defendant's own conduct when you're looking at a conspiracy, right? There is a Second Circuit case that was not briefed. I'd be happy to give the court the citation to that mentions Walden in relation to conspiracy theory. That's In Re Platinum, 61 F. 4th, 242. 61 F. 4th, 242, which the Second Circuit case that mentions that. I don't think the court should apply the doctrine strictly. I don't think Walden or other Supreme Court cases since Walden require that.
Well, thank you very much.
Thank you.
Appreciate your time, and we will come down and re-counsel. Go ahead for our next case. Please be seated. Yeah, I'm sorry, yes. I should have been clearer. We will now go on and hear our next case, number 251408, Metaldyne Powertrain Components versus Sansera Engineering. And Mr. Donovan, when you are ready.
Good morning, Your Honors. Thank you for having me and my client. I'm here for the appellant, Metaldyne. My name is Bert Donovan. It's lovely to be in the red courtroom. I must admit I was intrigued by the tweed courtroom. Thought it might be a little more warm and inviting. But,
This one is much better.
This one is absolutely gorgeous, and I appreciate this. I wanted to focus the court's attention, knowing how thoroughly you analyze the submissions, on the nature of this case, because it really is a mistake that needs to be corrected. This is a cost of recall and field actions case. And the recall and the global field service actions related to the case were necessary to eliminate an unreasonable risk of vehicle safety. In this case, a blocked rear wheel on a motorcycle that could cause a crash. And what happened is, if you were to have a fracture of a pin, you would have the ability to have two gears engage at once, lock the rear wheel, and have a loss of control. The risk of the pin fracture is what we hear about, because the risk is what a recall addresses, not the actual fracture itself, because if you did that, it would be too late. So why would you have a field action? It's mandated by a federal statutory and regulatory scheme. And it starts backwards from the risk to the end user, the operator. If there's an unreasonable risk of motor vehicle safety, the mandate in the Code of Federal Regulations, the regulatory scheme that follows the Safety Act, requires the manufacturer and the equipment manufacturer and everybody in the supply chain to comply with the recall obligation. It's mandatory. You saw some words that essentially said that Metaldyne caved to BMW. Protecting the safety of end users, not only is it appropriate, it's necessary, and it's mandated by statute. So when you are implementing a recall, what you're doing is risk avoidance, not property damage. Again, if you're addressing property damage, damaged transmissions, damaged pins, you would be too late because you wouldn't eliminate the risk. And the risks that we're talking about exist in a population of suspect motorcycles. And the reason it's a population is that when you have what we have here, which is the failure to make parts consistently using heat tempering that would make the parts resistant to fracture, so they're tough enough not to fracture when used. If you don't do that properly, and you do it randomly or erratically, which the record is replete with that, what you create is a population in which some parts are okay and some parts are subject to fracture. So you need to get that population, the suspect population, and take all of the parts that are at risk and replace them. But they're not broken, they're not damaged, but they have a risk associated with them because of a manufacturing issue. The manufacturing issue relates to the parts of the contract under which we sued. And that contract allows for warranties, a variety of warranties, expressed and implied. And the express warranties, the promise in section 8.1, is that the parts will meet the specifications, performance criteria, and they won't have any material issues. And they will be fit for their purpose, which means a motorcycle fork, which is intended to assist and ensure the shifting of gears, works as a motorcycle fork, transmission fork. And the pin within that failing was the material issue. The material issue relates to the failure to meet the warranty with respect to the appropriate manufacturer of the goods by failing to follow your own rules with regard to heat tempering, which provides the resistance to fracture, which makes these safe. And the bottom line here is if they made what they intended to make, using the processes and machinery and temperatures and times and quenching that they promised to do, you don't have a problem. It's only when they deviated from that that you have a problem. And that's what BMW told the federal government in this recall report. And so right from the jump,
Can I ask you a question?
Yes, sure.
So, as I read your colleague's brief, they were really focused on the scope of the settlement with BMW in this case and what exactly was released. Can you explain to me basically what the scope of the settlement is? Does it only cover recall costs, or does it release claims, all claims related to this, I'm not a motorcycle person, but to this transmission? Like even if it were a property damage claim or something, or personal injury claim?
BMW didn't make any property damage claim, but there is a broad release that covers a variety.
Can you speak up a little bit? I
Yes,
can't hear
yes.
you, I'm sorry.
I'm a little farther than the microphone than I'd like to be,
Yes.
but apologize for that. The answer was BMW did not make any of those types of claims, but the release is broad. But the focus isn't on what the release says, it's on what you paid for. And if you look at JA 747, which is a settlement agreement, and then JA 751, which is Exhibit A, what you have there is line item detail. And what your line item detail is, that's where we can establish that we
Sorry,
only.
can you repeat that?
Yes.
I'm having the same issue with volume. Could you repeat
Sure.
the citation you just gave?
Yes, it's JA 747, and
Okay.
I'm speaking as the exhibit JA 751, which has the line item detail.
Thank you. Just wanted to confirm I had it.
No, sorry about that. In the line item detail we're talking about all relates to addressing the risk associated with a fractured pin by only paying for the corrective actions in the population. Again, we're not talking about broken pins, in the population. And how do you do that? Well, you have to buy 3 good forks with pins, and then you have to put them into the transmission because there's 3 of these in each transmission. So that's one part of what we paid for, and that's right in there. And then you have to install it, so there's labor costs. That's the second part. But in order to do all of this, you have administrative costs. You have to mail people notices of their problem, and tell them to take it into the dealer. And you also, when you create a supply chain for replacement parts, you have to ship those parts and store those parts, and there's processing charges. So that whole line item detail, that's why you have such a precise figure with regard to what we've asked for. So the bottom line here is when you understand the nature of a recall, you realize that a recall can't address after the fact property damages. Because if it did, it'd be too late. It wouldn't be doing what the statute and the regulations require, which is eliminate the risk. So the recall was preventative, not repair to damage parts or transmissions.
Can I ask you a question? If, assuming just hypothetically that you are right, that Section 9 doesn't apply in this case, then what happens when the case goes back on remand?
Sure. Well, on our complaint, we would have the 4 causes of action in addition to the indemnity causes of action, which would be the breach contract, which would cover our warranty rights and the remedy obligations associated with those. Those would be 8.1, 8.3, which are specific to recall, and 14.
But let's, on the recall, if I read 8.3 and even under, I think section 14, the recall is referring to the recall, BMW recall. You would agree that you all did not conduct any recall?
No, because you can't conduct a recall as the component part
Is that-
manufacturer because you need to do the repairs at the vehicle and transmission level, and that's what is anticipated by the federal scheme.
So how would 8.3 apply, because this is 8.3 seems to discuss
Yeah.
in the event, actually it defines recall and the liability and damages in the recall if you all did not conduct a recall.
Your Honor, if you look at JA 281, which I think you're reading it,
One more time, I couldn't hear you.
I'm sorry, if you look at JA 281 and what you're reading in the second line of that, it talks about voluntary or government mandated offered by buyer or the vehicle manufacturer to remedy an alleged defect that affects motor vehicle safety. And then it's defined as a recall. And that's, why does it say it just like that? Because this is a contract that was written in a vehicle supply chain where you have the component, the pin, placed into an assembly, the fork placed into another assembly, the transmission placed into the vehicle, which is a motorcycle. And if you want to make sure you're covering yourself, you would want to make sure that the recall provision actually references the folks that have the ability and the regulatory obligation and statutory obligation to conduct the recall. So 8.3 gives you a right, 8.1 gives you a right, and 14 gives you a remedy, a non-exclusive remedy.
Right, because 14 also says, like, you have anything you would otherwise have under this contract or any other source of law, here's some more things you also have.
Exactly, and we point to it in our papers for the fact that property damages and recall are separate, but Your Honor, what you point out also points out that we can pursue this under the UCC 2315, which is
But your claim is for indemnification. In this, if I read section 14, it reads as if it is for direct damages. And I think that what the district court seemed to be struggling with is under section 14, she gave you an opportunity to go back and amend your complaint regarding your damages, because this reads as if it's direct damages. It says incurred by the buyer conducting a recall campaign, which I think we all can agree that your company was not conducting a recall campaign. This is an indemnification claim.
It is also a breach of contract claim, a breach of warranty claim, both expressed and implied, and the obligations for compensation appear both in the contract, including, we believe, 14, also in the UCC, because these are consequential and incidental damages. You can't fix what you needed to fix to eliminate the risk without doing these things. So we have multiple paths to this. I'm sorry, go
The
ahead.
district court did give you an opportunity to go back and supplement damages. I think that's the struggle that the district court was having, is that the only damages that you have sought are damages related to the indemnification. So there are no additional damages that have been alleged other than and I think, I want to say, I think your experts can see that the sole source of the damages is just a settlement payment, right?
But the settlement payment was for the activities of correcting the defect associated with the manufacturing issue that created the at-risk population. And where the judge got it wrong was Section 9, which is actually not preclusive, it's very narrow, doesn't apply here. It only applies, it says product liability right at the top, and it's after you have this opportunity to do recall separately and warranty separately. And it says injury, death, or property damage. And where the judge got hung up was on property damage, because that was the misapprehension. That's why I started with what a recall does. If a recall only associated itself with property damage, it wouldn't be effective because you would have already visited the risk upon the public. You need to arrest the risk before it manifests itself, before property damage occurs.
So this is why I was asking sort of what would be left for the district court. If we agreed with you that Section 9 doesn't apply, I would think it would be up to the district court to figure out whether Section 14 applies, whether Section 8.3 applies. Like, that's, all the district court said was that 9 applies and you lose under 9.
But they said it was exclusive to the district court. She said it was, the judge said it
Well,
was.
but I think what Judge Benjamin's pointing out is the district
Yeah.
court then issues some other orders that dismiss other claims. But would your view then be, but that's all infected by the district court's initial
Exactly.
mistake that Section 9 applies in the
Exactly.
first place?
And the property damage assumption, which is inaccurate. It did infect everything. And what it did is it took you an eraser, because Judge Harris, what you were pointing out is, Justice Harris, you would be actually combining paragraph 8.1, paragraph 8.3, paragraph 14, the UCC implied warranty and the UCC remedies provisions, plural, and the implied warranties, plural, in order to give you multiple paths to the same goal, which is to recover the costs associated with buying new forks that aren't subject to fracture, finding the forks that are subject to fracture and replacing them, and taking care of an at-risk population, some of which includes problematic forks and some of which doesn't. That's just the very nature of a
But
recall.
even if we send it back to the district court on Section 8.3, you still have the same issue that you had under Section 9, because it says that you are supposed to negotiate it on a case-by-case basis. It's supposed to be a good faith allocation of responsibility for the recall, and that the costs and damages incurred in other relevant factors. None of that occurred here.
The opportunity to do so was precluded in two major ways. One is, if you recall back in 2018 when this first came in, the day, I think it was the 18th, it was August, maybe the 12th, we said, hey, what's going on here? They sent a guy out to the plant that was doing the heat treating, and that evening he found out things were very, very bad, and he sat on it, and they buried it. He didn't sit on it with his bosses sat on it with us. So at that moment, 2 years before the recall, they knew what was causing the deviation in field performance. It was a lack of controls regarding manufacturing. And then there's a lot made in their papers regarding what happened waiting 2 years later in 2020. Well, it wasn't waiting 2 years. They were aware as we were aware. And then as soon as they found out about that, what did they say? There is no evidence that this is a problem. They say that this is a stray. And I would draw your attention to JA 229 to 232. Having gone on site and found issues related to a defect that is exactly related to the BMW description in the 573, and then saying unequivocally, we have nothing, and this is a quote-unquote stray, misleads us. You can't be part of this continuum of negotiations when you started out with a false premise upon which everybody relies.
Counselor, you're a little bit over, but you have time on rebuttal, unless, did you have more questions?
Thank you, Your Honor.
Good morning, y'all, and may it please the court. I'm Kevin Hall, representing the appellee here. I'm joined by Levi Wright here. I'll introduce you to him. He is a brand newly minted University of South Carolina law grad, and this is his first week on the job, so he's here for the fun. Let me begin by saying Section 14 and Section 9 operate in tandem, not in competition with each other. They are have distinct roles that are defined by the contract. And really what the delineation is whether you've got a first-party claim or a third-party claim. If you examine Section 9 and, by comparison, Section 14, you'll notice that Section 14 talks about warranties between the buyer and the seller. That is between Metaldyne and Sansera. It's all in the context of warranties. Well, warranties are always between the parties to the contract, not third parties. Nowhere in Section 14 is the word third party used. Nowhere is indemnification used. It envisions exclusively.
Okay, but it seems to me that you're setting up a false dichotomy, which is that this case must be governed by either 14 or 9, and I'm not sure why that's necessarily true. My bigger problem is I don't understand why 9 applies here.
9 applies here because this is a third-party claim. This is
Sure,
not-
but it doesn't say all third-party claims. It says third-party claims. This strikes me as just the absolutely critical language that, with respect, I'm not sure the district court ever grappled with. For bodily injury, death, or property damage.
Right.
I don't understand how any of these claims are for bodily injury, death, or property damage.
Property damage occurs when you have a component part of a larger product that damages the larger product.
How does it damage, it damages the larger product in the sense that it makes the larger product not work?
Well, it makes it not work, or if...
Sorry, like when I said, like, I totally would get for property damage if, like, let's say this was a component of a toaster,
Right.
and the component exploded inside the toaster and damaged the rest of the toaster. That, I guess, I can conceptualize as a claim for property damage,
Right.
but that's not what happened here, right?
It is what happens here.
Well, in fact, they say over and over and over again that not one penny of the money that was paid to BMW was for situations where a motorcycle exploded.
Well, look...
And you don't agree with that, but I've read your brief extremely carefully. At no point in the brief, they assert it over and over and over again. Not one red cent of this payment was for an exploded motorcycle, and nowhere in your brief do you say that's not true.
Well, that's a lot to unpack.
But is that factually true, that nowhere in your brief do you ever once deny that not 1 cent of this was for an exploded motorcycle?
Your Honor, I
Because
don't...
I'll follow up by asking you on what page in your brief do you say that if
Well,
you claim that you do.
Your Honor, I get the question. Here's the point.
So the answer to my question is no.
Well, they paid for...
No, sorry. I asked a very simple question. In your brief, do you ever once take issue with the claim that not 1 cent that was paid to BMW was for an exploded motorcycle?
Your Honor, I think that
This is a really easy yes or no question.
Your Honor, we don't talk about exploded motorcycles.
Great.
We talk about what they bought, okay?
Okay.
Your-
I'll take that as a no.
Your toaster example, this is akin to your toaster example. The allegation is that a shift fork pin is too brittle and it breaks. And when it breaks...
No, the analogy to mine is that someone realizes there's something in the toaster that might make the toaster dangerous or not work, so as a preemptive matter, before any toaster explodes, we're going to go replace all the toasters. That's the analogy to my hypo.
Well, here, BMW had field events where toasters did explode, where motorcycles
But that's
didn't
not
operate.
what BMW was paid back for.
Well, they were paid, BMW released Metaldyne for any claims that could come out of those, including bodily injury. Now, they want to tell you that the release is, oh, well, it says we
So
got a
wh-
release from everything, but we didn't really paid for something else. They got a complete release of all third-party liability.
Okay, let me try this a different way. What's your best claim for the proposition that what we're talking about here is a claim for property damage?
When you put...
No, what case? What decision of what court should I read for the prop? Because I will say, as a textual matter, this just does not seem to me like a claim for property damage. And so, if you have authority of some court that says and explains, because again, with respect to the district court's opinion literally just asserts this. It never explains why this is a claim for property damage. So I'd like, if you know of a case that explains why this is properly understood as a claim for property damage, what case is that?
Penn National and Thruway.
Okay.
Penn National and Thruway stand for the proposition that when you put...
Remind me again what court decided that case?
I'm going to rely on my colleague, or let me look at my copy here. These are an Eastern District of North Carolina case, which is Penn National, and Thruway is a Western District of New York.
So
case.
what it definitely is not is a decision of the Supreme Court of the relevant state or a decision of this court.
That's right.
Okay.
Again, they stand for the proposition that when you have a component part, the Penn National case is bad chicken blend went into dog food, okay? And so what does that mean? Is that property damage? And the court says, yeah, when you damage another party's property, that is property damage. Because you
Sorry,
had
it's bad chicken, what?
bad chicken blend went into dog food, damaging the dog food, okay?
Well, but, I
That
mean,
sounds right. That seems different, and that seems intuitively correct, just as a matter of common sense, like the
Well,
dog food was bad.
like if
Well-
I stir a rotten onion into a mixture, it's gonna make the whole mixture bad. So
And
that seems intuitive how that maybe
When
is
you
damn.
put a bad shift fork assembly into a transmission, you do the same thing. You destroy the transmission.
But, okay. Can I ask you another question?
Sure.
We've talked about property damage, but I also don't understand, I mean, this is a product liability provision. That's what it's for. That's the title. The whole last part of it is about the seller obtaining product liability insurance. And this certainly isn't a product liability claim, right?
Well, look, the heading says product liability, but the distinction is who is seeking recovery?
Right, and
The-
for a product liability claim, it has to be the end user, and we don't have any claims here by end
Well,
users, so what's going on?
You have any end user complaint, any end user case is going to come up through BMW to Metaldyne to Sansera. It's a third-party claim.
Just as a can I take us on the tort law of it? Just make,
Sure.
like, let's say a motorcycle had counterfactually exploded, and let's say someone injured by the exploded motorcycle wanted to sue people. It's been a while since I've taken torts, but my sense is they could sue BMW. Obviously, BMW sold them the bad, well, they could sue the dealer that sold them the bad motorcycle, then they could sue BMW, but they could also sue Metaldyne and Sansera, right? Like, under tort law. Everyone who, like, the fact that they can sue BMW doesn't mean they could have only sued BMW. They could sue all of these people under. Now, as a practical matter, BMW is a gigantic multinational corporation that essentially has bottomless pockets, so you'll probably just sue BMW. But you could sue the part manufacturer under tort law, right?
Well, look, you can certainly sue Metaldyne, whether that comes all the way up to any privity with Sansera is another question. But the point is, if Metaldyne settles those claims
Sure.
with BMW or with that injured rider.
So, like, they sue Metaldyne, and Metaldyne is liable, and then Metaldyne brings a third-party claim against Sansera. It's like, the only reason that our thing was bad was because you gave us a thing that was bad that made our thing bad. So any liability we have to the customer now flows to you. That's how it would work? Okay.
And that's Section 9.
Well, I mean, that's also tort law 101.
Right, it's Section 9, and that's what we have here. We don't have, let me give you an example of how 9 and 14
So
complement
where
each
is
other.
the product liability claim in this case?
The product liability claim here is what they bought with a release. They bought releases from those product claims, at
But
least,
they bought it from BMW,
yes.
but BMW can't bring a products liability claim. I'm just
No.
confused.
When BMW gets sued for products liability claim and they try to come upstream, Metaldyne's off the hook. Metaldyne paid for that release.
You mean if BMW gets sued? Because based on the evidence in the record, BMW was never actually sued by any customer injured by an exploding motorcycle.
Right, that's why I was asking, where is the product liability claim
Well, look,
here?
they haven't sued as of yet. I mean, that doesn't mean they can or they won't, and it doesn't mean those claims weren't settled and we don't know about them. The point is they're downstream claims. If I might, let me walk through a factual scenario that I think demonstrates the interplay. Let's say that Metaldyne, is receiving shipments of shift forks. They say, hey, we notice we've got a problem here. We think some of these aren't hard enough. We think we've got a brittleness issue. They inspect, they shut down the line, they inspect, they check it all out. That's 14A, right? That's breach of warranty, a claim under Section 14A.
The stuff you gave us doesn't have the characteristics the stuff you gave us is supposed to have.
Right, and so we've got to inspect, sort, we've got to figure it out, and we've got to put our line down to figure it all out. So we've lost production time. That's 14A and 14B. These are direct implications between the two, right?
Okay.
Let's say at the same time, they've got that downtime. Metaldyne says, look, to Judge Benjamin's question, we better conduct a recall ourselves, all right? We better call BMW and send some folks out to their plant to make sure that the transmissions that are there have good shift forks in them, and we'll pull them, we'll pull them back, and we'll do some work. That is 14C. That's conducting recall campaigns and taking other corrective actions. Again, it's breach of warranty. Let's say that when they come back and they're doing the testing to verify and figure out what's going on with these transmissions, one of those shift fork pins breaks, tears up the transmission, tears up the testing equipment, cuts through the wall, which is what happens when these engines explode, and sprays hot grease, oil on somebody and further damages equipment. That's 14D. That's personal injury and property damage, again, between who? The first parties, the parties to the contract. Now, let's assume BMW launches its own recall. BMW launches its own recall and says, hey, we got riders out there in the field, we got to have a recall, and again, here, remember, it was BMW, not Metaldyne that did the recall. Any of the recall costs that BMW incurs and passes upstream, that third-party recall expense, that is a Section 9 expense. It's not a breach of warranty between Metaldyne and Sansera. It's a third-party indemnity claim.
Wait, say again, what was the beginning of that sentence?
I'm sorry?
Can you just say that sentence again? What is it that is a third-party indemnity claim?
BMW's attempt to recover the cost of its recall is a third-party claim. It is a third-party claim. They are not a party to the contract. No warranty has been breached to BMW. They are seeking recovery, not because of a breach of warranty between the parties to the contract, but they are seeking recovery downstream.
So I agree with you 100% it's a third-party claim.
Right?
The question for me is whether it's for property damage. I have assistants who help me. Both of the two cases you cited to me, in addition to being non-controlling, involve contracts that defined what property damage means. There is no definition of what property damage means in this contract, right?
Well, they define property damage, I think.
Do you disagree with the proposition that both of the two cases that you cited to me a few minutes ago involve contracts that defined the words property damage?
I understand them to define the word property damage by referencing something else. The courts, in those cases, as I read them, says, look, property damage is a damage to a tangible item, a tangible good. Then they have other exclusions and say, for the purposes of this contract, we're going to take this out of the definition of property.
That's a definition.
Right. But fundamentally, whether something is property damage or not.
It's just not clear to me how much a non-controlling case from out of a jurisdiction that involves a contract that defines the term in question tells me much about how to define this term in this contract.
Well, Your Honor, I don't see cases that say on the other side, analogously, I think it's clear when you damage a third party's property with your good, that's property damage. That just logically makes sense. It makes sense in the dog food context.
Well, but it starts to violate, it also starts, let's say this was a statute, not a contract. It starts to violate all kinds of rules of construction that would apply if this was a statute. I know it's a contract, but it's not just the words property damage. It's, as Judge Harris pointed out, it's in a provision that's captioned product liability, and then it says for bodily injury, death, or property damage. I think we can all agree that the first two of those three terms sound like a motorcycle exploded and hurt an actual person. And so then that would, I think this is a Euston Generous, I can never remember, would suggest that we should on balance construe property damage as things of the same nature as bodily injury or death. And we put a bad part in, and as a result it doesn't work so well, doesn't seem super analogous to death or bodily injury.
Your Honor, you heard the entire argument that you received from my colleague was how dangerous this is, how much of a risk this is to the traveling public.
Yeah, but if it said risk of bodily, yes, it may well have created risk of bodily injury. It may well have created risk of death, but claims for risk of bodily injury and risk of death are not the same as claims for bodily injury and death.
And they got a release for bodily injury and death, Your Honor. That's what they bought. Now, they would like to say, oh, well, look, we paid for what the release says, but that's not really what we bought. You heard it said, we paid for something less than what the release says. That simply can't be true.
Did you understand the district court to adopt that reasoning that there's something about the scope of the release here that was animating the district court's decision? I thought the district court just thought, look, recall costs come under 9, the property damage.
Your Honor, we went back and forth with this a couple times, as y'all know, in 2 rounds of briefing with the district court. the district court focused on an analytical sequence that goes like this. Who is making the claim, and against whom are they making it? Because whether it's a first-party claim or a third-party claim really determines whether it goes to Section 14 or Section 9. Well, the claimant here is a third party, okay? The first sentence of Section 9 says, seller shall indemnify Metaldyne against third-party claims against buyer, Metaldyne, or its customers, BMW, okay?
How is BMW the customer? When I read,
BMW buys
no,
transmissions.
I'm sorry, I didn't mean it in the literal sense. Legally speaking, it's a product liability provision, so I read this like the customers are the end users, the people who can bring a product liability claim.
It says against buyer, Metaldyne, or its customers. Metaldyne doesn't sell any product to motorcycle riders. They sell
Right,
to
that's why I'm wondering why
BMW.
this thing applies
The
at all.
buyer is BMW. The customer is not an end user. The buyer is BMW. That's the whole point.
No, okay.
Again, let me try to drill down on this. Look,
No, I'm fine.
Section 14 is exclusively between Metaldyne and Sansera. The warranty's between them. Section 9 says when you get past those two, that's a third party. And that's third-party claims asserted against buyer, Metaldyne, or its customer. Who's its customer? Its only customer is BMW.
Right, and that's how you read the provision. I'm suggesting the fact that there is a product liability provision that runs against a buyer or its customers. In most contexts, what we're going to be talking about is the end user customer. I agree with you, there's no such person in this case.
Your Honor, respectfully, I mean, that is absolutely precluded by the language of Section 9. I saw a light bulb, I thought, go on when I said customer
Oh my
is.
goodness, well, I'm sorry the light bulb turned out to be a mirage, but maybe we should probably just move on.
Okay. Yeah.
Let me ask you this,
Sure.
because counsel on the other side is making this argument regarding 8.1 and 8.3 being the more, is where I guess we are in terms of where this claim lies. And I'm curious to hear your argument as to, I guess, 8.3 or 8.1. Now you've already discussed 14. I think that his argument is 8.1, 8.3, and 14 kind of all work together to give him his damages on the indemnification here.
Well, the question, I think, is, you know, Section 8 talks about the warranties, right? The things that can happen. But the question is, how do they recover them? And 14 and 9 determine what pathway you have to go to recover them. Now, look, if they were engaging, they said, look, Sansera, you breached your warranties to us. We're talking to you about those warranties to us that you breached. And they had a settlement between the two of them, that would be under Section 14. What Section 9 does is guarantees that if Metaldyne goes somewhere else and tries to write a check on Sansera's account, doesn't include them in the discussion, doesn't give them a chance to participate in the settlement discussions, and goes and writes a check without their consent, that they're forced to be in the loop at the same time. And they're complementary in that way. Otherwise, you have them out writing checks on somebody else's account without that participation here of Sansera. That's why we say the reading that they're offering you guts Section 9. It guts Section 9. It lets them recast every breach of contract, every indemnity claim as a breach of contract or breach of warranty claim. That's what they're doing here. And by saying, well, this is breach of contract, this is breach of warranty, this is not indemnity, they gut Section 9. It allows them, if their reading holds, that they can go settle cases out there, and they don't have to get any consent or give notice of those claims. So again, if, in terms of contract rules of construction, if we're supposed to give effect to all provisions, how can that be? How can Section 14 be read to gut Section 9? And we cite cases that speak to that. When you're seeking the same damages in indemnity and in breach of warranty and in breach of contract, it's the indemnity claim that survives. You can't recast those as breach of warranty or breach of contract to circumvent the notice and consent provisions. Thank you.
Thank you.
I'll keep my comments very brief. I wanted to start by making sure that I adequately addressed Judge Benjamin's question earlier. I was short on time, and I'm concerned that I may not have fully articulated a response that would be helpful to you. So with regard to Section 9, if we want to have that discussion, just we know it only applies if this is a property damage claim, and we don't agree with that. But even if it was, it shouldn't erase, in our view, Section 8.1, 8.3, and Section 14, which also work in concert. I agree with counsel that to the extent Section 9 applies to anything, it would work in concert with 14. But so does 8.1, 8.3, and Section 14. And remember when I started here, one thing I was careful to point out is that this is a cost of recall case, and a recall responds to a safety risk. Warranty, on the other hand, is often focused on the performance of a product against specific measuring sticks, and that's what we have here in 8.1. But the fact is, while not necessarily so, a breach of warranty could be the cause of a safety risk in a recall, and that's what happened here. The safety risk that manifested itself was as a result of the breach of warranty with regard to
But wouldn't that be the breach of
manufacturing.
warranty between, his argument is that the breach of warranty is between Metaldyne and Sincere under 14 and not BMW, which is who conducted the recall campaign.
Again, we don't agree it that way. It was just explained in our briefing. But also, Section 14 is not exclusive. It's not exhaustive. Those are a list of things in addition to anything else you get, which is contained, one, elsewhere in the contract under 8.1 and 8.3, and also under the UCC, the implied warranty is fitness for purpose. When parts are fit for their purpose because they're consistently manufactured, they don't have a tendency to fracture and cause a wheel lockup, is our point of view. And we think there are multiple paths, which is why we had 6 counts in our complaint, to these types of recoveries. And in my 35 years of doing this, that is typical in the experience to have those multiple theories and paths because they are in parallel. And where we really take exception here is to the exclusivity argument in that Section 9.1, we just don't think it's a property damage case. And 2, if it's not an exclusive provision, it doesn't erase the other provisions and rights.
But you would agree that 9 is the section that really talks about an indemnification, and that is what we have here.
Respectfully, Your Honor, I don't agree with that. I agree that it says the word indemnity, but the right to get paid for things that we paid to others is very clearly allowed. And what's interesting is the criticism seems to be from the other side, is that the fact that you have a very specific contract tuned to the supply chain that gives you recall recovery rights associated with a recall that your customer has is insufficient. It's a straight line to the damages we're seeking right in the language of the contract. And they want to take an inapplicable paragraph and erase the specific. And with regard to the other part of your question, Your Honor, you had indicated, weren't they precluded from participating in the negotiations? They excused themselves from doing so in 2 ways. One, as soon as they found out in 2018 they had a manufacturing issue, which incidentally was turned off because they pulled that supplier right away, so the risk was frozen at that point with regard to that manufacturing issue. They hid it, and we didn't find out until just after, I was right at the end of 2024, 5 a.m. depositions. I remember hearing this and going, that's what happened. That's what they did. They buried it. And the problem is the judge didn't have that because, in our view, inexplicably, during the year that this was under consideration, the first motion for summary judgment, we couldn't take depositions. So the consent being either gotten, pursued, or unreasonably withheld was never vetted, so that was premature. And then fast forward a couple of years, which they say is too long, but that's when the additional accidents that manifested this risk occurred. And what did they do? They doubled down on the inaccuracy. At JA 229 and JA 230, they say, we would like to conclude that this is a stray case of failure, and Sincere is not responsible for whatsoever cost implication to this failure. They wrote that 2 years after they had a guy on the ground in a plant saying, we got to get out of here. There's a problem. They're not doing anything they agreed to, and they're using the wrong equipment. They shouldn't benefit from that misleading. It just, not only does it preclude an actual negotiation and consent, it also set everybody on a course that could have been easily avoided, because exactly what BMW said happened was proven to have happened in 2018.
But they were excluded from the negotiations, the settlement negotiations.
They
correct?
excluded themselves, Your Honor. They refused to negotiate, they refused to discuss, they gave us flat denials, and during the denials, they used language that they knew was inaccurate because they'd already concluded and confirmed that they weren't making these parts properly at their supplier. And then, to be honest with you, it's all over the briefs in this court. They shouldn't be saying to anybody that they didn't know the parts were being made improperly because they found out about it in 2018.
All right, we're going to come down, sorry, and Greek counsel, and then
Thank
we'll
you
hear
very
our
much.
third and final case. All right, everyone should be seated. The lawyers for the third case should come up, and we will, as soon as they are ready, move on. Okay, we will hear argument next in number 251094, Natalie Thomas versus EOTech, and Mr. Santo, whenever you're ready.
Thank you. Good morning, Your Honor. May it please the court, my name is Jordan Santo. I represent the appellant Natalie Thomas in this matter. Today we're dealing with a case that turns on one of two questions. One, whether or not the timeline provisions and the timeline requirements, the timeliness requirements of Title VII, the ADEA, and the Maryland State analogous statute are substantive rights under the law or are waivable pursuant to contract with regards to limitations. Point two, if they are waivable, whether or not the waiver or the limitation in this case was a reasonable limitation.
Mr. Santo, I think you just answered a clarification question I just want to make. You're not appealing the dismissal of the Section 1981 claim, right?
That's correct, Your
Thank you.
Honor. And I double-checked the notice of appeal, and the notice of appeal does specifically state the Title VII, the ADEA, and the
Just want to confirm.
MMEA. But I would agree, Your Honor, and that was discussed extensively, I believe even admitted during argument at the district court, that there is precedent in case law that establishes that limitations provisions for Section 1981 claims are permissible.
Sure.
And the difference that we have here is that this is not a 1981 claim that we're dealing with. It's Title VII, ADEA, which do have the requirements with regards to exhaustion of administrative remedies that don't exist with Section 1981. And at issue here is a tension between precedent or case law in the Sixth Circuit, specifically Logan v. MGM, which was briefed in our briefs and at the lower court, and then case law from this court, In re Cotton Yarn. In re Cotton Yarn deals with allowance for...
Well, let's start with Cotton Yarn, since one of those cases is binding on us and the other one is not. What is your how would you have us distinguish Cotton? Presumably you would have us distinguish Cotton Yarn. What are the two or three bases on which you would have us distinguish Cotton Yarn from this case? Because we can't write an opinion ruling for you without saying Cotton Yarn doesn't control here because.
Understood, Your Honor. And not only with cotton yarn, but with the other cases from the Fourth Circuit and even the Second Circuit, and in some cases the Supreme Court that we deal with the timeliness issue, all of those cases deal with arbitration agreements and whether or not an EEOC charge has to be filed before the case is taken to arbitration. In re Cotton Yarn specifically deals with arbitration, and in a different aspect of it, the Sherman Act doesn't deal with the EEOC, so it's not directly applicable to Title VII. But if you look to Bracey, and I apologize, I don't have it here in my outline. Bracey v. Lancaster, or Lancaster Foods LLC, which is a Fourth Circuit case from 2020, that's an ADA claim in which there was a limitations provision in contract in the employment agreement. But again, the arbitration agreement was what was at issue there, and that arbitration agreement did not require an employee to file first with the administrative agency.
Also, doesn't Cotton Yarn make a fair bit of a point of the, like, unlike some situations where a Congress creates the substantive liability and the limitations period in the same statute, which this old Justice Holmes opinion says might be important for some reason, Cotton Yarn makes a point of saying that's not the case in Cotton Yarn. In Cotton Yarn, there's the liability provision, and then the limitations period is in a statute that's passed later as part of some other bill. Like, whether that's a persuasive distinction or not, it feels like Cotton Yarn says that's an important distinction. That was a friendly question.
I agree. I do think that there is some distinction, and it all still comes down to whether or not that subsequent statute, I think, directly points to the cause of action at issue. And so even if it's a separate statute that's either amending a right or clarifying a right, that's still a subsequent statute as opposed to a general catch-all. All contract claims, all tort claims have a certain amount of time in which they could be filed. I would also point specifically to the dissent in In re Cotton Yarn, which again, In re Cotton Yarn in part was unanimous to some parts, but Judge Johnston in his dissent dissented specifically to Part 2B, addresses that he disagreed with the majority and believed that the statute of limitations is actually a substantive right.
Why does it matter what a dissenting judge thought?
It matters, one, because it shows that it's not a unanimous decision with regards to the specific provision.
It turns out that 2-1 decisions are just as binding on us as 3-0s.
I agree, Your Honor, but it also, in addition, that plus the aspect that dealt with arbitration agreements gives room for this court to distinguish Cotton Yarn from this matter, because this is not an issue with an arbitration agreement. It's solely a limitations issue, and because this is not, we're now back into the realm of we're no longer dealing with a contract for arbitration in a separate forum in which rights can be pursued. But the emphasis, it's the definition of substance and the substantive right that's addressed in the dissent that discusses that the substantive right at issue is the limitation on the recovery, not when and where the cause of action could be obtained, but it's the recovery, the amount of damages that could be obtained, and that's an issue that's not waivable. So here, in Ray Cotton Yarn, it's an issue of when to bring the claims in arbitration. You don't have to exhaust administrative remedies. Here, the agreement did require, the employment agreement requires exhaustion of administrative remedies before filing in court.
Can I ask you a question about this substantive right concept here?
Yes, Your Honor.
I mean, as I read the case law, assuming the statute of, or the limitations period is a substantive right, that means it can't be waived if waiver would be contrary to the legislative policy behind the limitations period. Okay, but limitations periods are not there to benefit plaintiffs and make sure they have enough time to file claims. They're there to benefit defendants and make the plaintiffs hurry up and file their claims. So I am trying to figure out how a shorter limitations period is contrary to the policy behind a limitations period, which is a pro-defendant policy that puts a temporal limit on liability. Do you see what I'm saying?
I do, Your Honor, and I think that I point to a case that was cited by my colleague across the aisle, Zipes versus TWA, which is a Supreme Court case, which addresses specifically the jurisdictional aspect of the filing of an EEOC charge, but also discusses the congressional intent behind Title VII and statutes of it, which is the remedial intent to extinguish discrimination in employment. And so the policy issue here is to give maximum impact and maximum effect to the remedial impact of Title VII and the ADEA. So while a limitations period exists within the statute, as Zipes discussed, the purpose of the filing within a limitations period is to provide prompt notice to the employer. So it
But
doesn't.
now the notice will be even prompter. Like, why isn't it better that it's shorter?
Well, and the
Like,
reason why that's.
Again, I'm not seeing the conflict with the policy.
It's because this agreement itself, the way that the agreement exists, does not create a separate time limit between pre-filing with the administrative agency and post-filing. It creates a world in which an employee could file on day 180 with the administrative agency, have the case dismissed, and then would have no remedial effect in court. The other cases that address the limitations provisions all do so in connection with an arbitration agreement, and ostensibly all argue and discuss that in those circumstances, filing with the administrative agency is not necessary before bringing the claim. And so in that circumstance, in exchange for the shortening of the limitations periods in those arbitration agreements, it essentially discusses a waiver of the requirement that the employee then proceed first with the administrative agency. So the purpose, the remedial purpose of the statute still remains firm.
What do you mean by remedial purpose? Like, people should win if they've been discriminated against?
Well,
Is that what you mean?
The remedial purpose is to extinguish and eliminate discrimination in employment.
Okay.
So
But the way, I mean, it seems like if, just to paraphrase, I think this is Judge Easterbrook who originally said this, no statute that's ever been enacted pursues its goals to the absolute maximum, because if that was the maximizing goal of Title VII, there would be no limitations period whatsoever.
Right.
Because we would eliminate even more discrimination if we had no limitations periods whatsoever. So it can't be that that is the overriding uber alles purpose of the statute, because the one thing I know about this statute is it has a limitations period.
it does have a limitations period, Your Honor. I would agree with that, and I do believe that there does need to be some limit. But I would argue that the way that Congress enacted Title VII and the ADEA was not to limit access and availability beyond that time frame that they placed in the statute to seek that remedial
So
end.
this is like this sort of carefully reticulated remedial scheme, and Congress made judgments that you should get this much time but no longer, and saying that you could contract around that would upset the integrated remedial scheme of the statute?
And it's not just, and I would agree with that, Your Honor, but it's not just a A to B to C process. The purpose of the EEOC was to attempt to resolve discrimination at a lower level. Unlike other administrative agencies such as the Merit Service Protection Board, the National Labor Relations Board, the EEOC itself doesn't have enforcement power. It would have to then bring a cause of action.
I'm sorry, so it seems like your answer to me might be, this is not just any old statute of limitations. Most statutes of limitations, if you shorten them, that's not going to be contrary to the policy, which was to protect the defendant from unending liability. That's entirely consistent. But this one's different because it's part of this highly refined, carefully reticulated, larger conciliation process. And so if you start, it does things other than protect a defendant from temporally unlimited liability.
That's correct, Your
Okay.
Honor. And moving on, again, I think the largest part here is dealing with the specificity with the timing and the conciliation aspect of the EEOC charge, but then moving to the reasonableness with regards to the shortening of the periods.
Yeah, specifically, let me ask on that, I'm glad you went there. What is your best authority for the proposition that 180 days is unreasonably short?
I do not have an authority to say that 180 days itself is unreasonably short. I think the issue here is that this timeline does not split itself between pre-filing and post-filing, and then there's, it robs, or the 180 days can rob the employee of the opportunity to file the cause of action.
Well, because why? Wait, just walk me through this, and I'm sure it's in the briefs, and I apologize, I'm just not remembering here. How long does a person have to go to the EEOC?
They have 180 days under the agreement.
So if they, the hypothesis, no, I'm sorry. Absent the agreement, as a matter of like substantive law in the world, how much time would an employee have to go to the EEOC? To go to the EEOC?
Yes, so absent the agreement, it would be 180 days unless it's a deferral state, the state has an agency, then it would be 300 days for the federal claims to go to the EEOC.
So, okay, so in other words, they're saying 180 days could, if it was a deferral state, actually limit the amount of time you have to go to the EEOC. Literally, you could get timed out during the time that absent the agreement, you could still go to the EEOC in the first instance.
Yes, Your Honor. And again, utilizing that hypothetical, if that employee under this agreement filed on day 180, which is permissible, whether it's a deferral state or not with the EEOC, the moment that
Or a day 250 if it's a deferral state, right?
Right, so if they filed on day 181 or after, as soon as the EEOC dismisses that claim and issues the dismissal notice of rights, the employee would no longer have any avenue to recover in a private cause of action, and arguably, it would completely rob and defeat the purpose of the administrative agency process and then also the claims. So I think the issue here with reasonableness really addresses not only filing with the agency, but then filing with the court. Under this language, although the 180-day period is told during the process, as Your Honor stated, if they filed on day 200, while the federal claims could have, without this agreement, proceeded then within 90 days of dismissal to court, under this agreement, they would not be able to do so.
Can I move you to the state law claims?
Yes, Your Honor.
I'll just state up front what the dilemma for me here is. I think you have actually a quite plausible argument under Ciccone, if I'm pronouncing that name correctly, that there should have been tolling under the state law claims, but I'm not sure in any way you've preserved the argument. So in your brief, you basically treat the state law claims as if they're governed by the same principles as the federal law claims. Why is that?
Yeah.
I mean, don't we all agree that whether or not you can shorten a limitations period under a Maryland statute is obviously a question of Maryland law? I don't know why federal law would possibly care if you can shorten a limitations period on a Maryland cause of action.
I think the briefing really addressed whether or not the timeline and the timing in the Maryland statute, the analogous Maryland statute, also constituted a substantive right as opposed to a waivable
But
or
in
shortening
principle,
right.
the federal courts and the state courts could give completely different answers to that question, right? Because the state courts could say, barring some federal constitutional issue, none of which is immediately springing to mind, Maryland courts can say the rules are whatever the Maryland courts say they are, right? And there's no reason they have. So, like, I don't see any argument in your brief that engages the framework that the Supreme Court of Maryland has said we're supposed to use for deciding whether you control a Maryland limitations period.
Fair enough, Your Honor. And I think the argument there is really with regards to the reasonableness aspect, because Ciccone does speak to reasonableness, and it lays out different factors in which the courts are
Right,
to
and which
consider.
factors do you think cut in your favor here?
I think the biggest one is whether or not the limitation applies to both sides or one way.
And where is that in your brief or in your briefs before the district court?
It is not. That specific aspect of it is not, but the issue of whether or not the limitations period is reasonable is. But I would agree that that specific language is not in the briefing here, nor was it argued specifically at the district court. So again, Your Honors, I would ask that, primarily speaking, that this court find that the limitations period contained within Title VII, the ADEA, and in this case also the Maryland statute, is a substantive right, or alternatively that the, even if it is waivable under In re Cotton Yarn, if that were to apply, which we argue that it doesn't and is distinguishable, that the shortening of the limitations period, particularly in the fact that it doesn't distinguish between pre-filing with the agency and post-filing, is unreasonable, and that this court reverse and remand for additional proceedings. Thank you.
Thank you.
Your Honors, good morning. I think it's still morning, and may it please the court. My name is Donovan Asmar. I am the attorney for EOTech LLC. It is an honor and privilege to be before you today. I'd like to focus, if I may, and please ask whatever questions you'd like, but the district court in this action took great pains to analyze binding Fourth Circuit precedent and held that under that precedent, the limitations agreement in this action that was signed by plaintiffs separately is not in conflict with Fourth Circuit precedent. The
Well,
key.
let's start off by having a conversation regarding, because In re Cotton is arbitration, the arbitration agreement, which in that case, it seems to me to be it seems to be more procedural than a substantive right, because clearly, once you go into arbitration, the parties there still have an opportunity to get relief under. Here, it is, if you're talking about exhaustion of remedies, it seems as if you're cutting the right, the substantive right, if if you accept what counsel says is a substantive right, you're cutting off the amount of time through exhaustion of remedies where they have no recourse here, whereas in an arbitration agreement, it's basically determining the forum.
I have two responses to that, if I may. The first is, it is not settled that enacting a limitations period or enacting a shortened limitations period deprives a plaintiff in a Title VII or in an ADEA case of the jurisdiction of the courts. That's number one. Number two, with respect to the limitations agreement, the important feature here, unlike Logan in the Sixth Circuit, and unlike a lot of these cases that have appeared in the arbitration context, is this limitations agreement has a tolling provision. That provision was not in front of the Sixth Circuit in Logan, and to my knowledge, has not been in front of any other circuit in this country. That tolling, I'm sorry, Your Honor.
Please, finish your answer.
Your Honor, Judge Benjamin, that tolling provision is consistent with the purposes of Title VII. It preserves the plaintiff's ability to seek and access the EEOC's procedures.
Even if it's 1 day.
I was just going to get there. Does it shorten the time period? Of course it does. Of course it does.
But it doesn't just shorten the time period to go to EEOC, sorry, to file suit. So the hypo that your friend on their side did. So let's say we're in a tolling state. So under federal law, I have 300 days to file a charge with EEOC. I file a charge with EEOC on day 250. As in, from EEOC's perspective, it's 50 days before I had to file this. EEOC investigates, and they think pretty seriously about bringing a government action, but they don't because of budgetary restrictions or whatnot. So they issue me a right to sue letter. I get a right to sue letter that says, it's from EEOC, that says, you have 90 days to file a lawsuit. But I don't sleep on my rights. I'm like, no, I'm gonna. So I literally, the day I get that letter, I file my complaint in court. And under your view, my suit is untimely, right?
If it's a 180-day toll, 180-day provision like we have in this case, Your
Yes.
Honor? Yes.
So even though the statute says I have to go to EEOC, the statute says I have 300 days to go to EEOC, I did that, and I'm time barred.
Yes.
Oh, and sorry, under the statute, I have to go to the EEOC. I'm forbidden from going straight to court, right? Like, I have to go to the EEOC first.
Yes, but.
Okay.
Yes, you have to go to the EEOC, but nothing also prevents you from filing suit and seeking a stay of that action pending the EEOC's administration process.
Can I just say, I feel like we're maybe over on the reasonableness side of things, and I do understand, I think, your argument for that 180 days is maybe not unreasonably short exactly, but what you are describing is extremely complex and cumbersome, and it also, there's this real potential for misleading when a potential plaintiff gets a letter from the EEOC saying you have 90 days, oh my gosh, I don't know what's wrong, 90 days to sue, and that turns out to be wrong. I mean, this just seems the scheme you are setting out where people are going to file for stays in district courts, that is not what Congress intended when it set out this complicated, integrated scheme of relief. It clearly isn't what was intended, and it's going to mislead a lot of would-be plaintiffs.
Let me respond in this way, if I may, Your Honor. Any shortening of a limitations period would have that effect, right?
Right, that means maybe you can't do it under Title VII, which has this very integrated, carefully reticulated remedial scheme.
Congress could have said in Title VII or any other discrimination statute that you may not shorten this limitations
You
period.
mean kind of like they sort of said in the ADEA,
That's fair, Your Honor. But the point
which is one of the claims at issue in this case, that you purported to shorten the amount of time people have to sue?
But that also we have to consider that, number one, in this circuit, the law has been for over 80 years that parties are free to contract to shorten a limitations period, so long as,
That's the one sentence of dicta in Cotton Yard that's you're relying on?
well, it also comes from Atlantic Coastline, Your Honor. That's a 1941 case. So it's not just Cotton Yard. It comes from Atlantic Coastline.
Can I take a step back?
Please.
So we've been talking about the specifics, and Judge Harris is right.
Yeah.
I think that some of these specifics, but I would take like a step back. So the motion you filed in this case was a 12B6, right?
Yes, Your Honor.
So that's a motion to dismiss for failure to state a claim on which relief can be granted, right?
That's correct, Your Honor.
Okay. And because it was untimely, right?
Yes.
That's the theory. And we've said before that statutes of limitations are an affirmative defense, right? That there are cases that it's an affirmative defense that has to be pled, right? So what you're essentially saying is that the parties by contract can create an affirmative defense to a federal question lawsuit? That seems really strange. I don't understand how you can by contract create an affirmative defense to a federal question lawsuit in the first place.
I'll put it to you this way. I think the district court recognized that. And I think that's why the district court converted the motion by stipulation of the parties to a Rule 56
But that doesn't really,
motion.
yeah, I get that. So, but still, the district court then granted summary judgment for you on the grounds that the suit was too late. In other words, the district court found that you had and I don't blame the district court in any way. We have Cotton Yarn, we have the unpublished opinion. It's nothing on the district court. But the district court essentially ruled that you have a substantive defense to a federal question lawsuit that the parties created via contract. And that just seems weird that you can even do that.
Help me with the weirdness, and I'm sorry to
Well,
put
because
it
Congress-
back to you, because
Well, okay, so let me give you
I
the analogy.
get-
The analogy that really
Yeah.
struck this with me. So the Supreme Court a number of years ago had a case about how you enforce forum selection clauses. And some parties in courts had argued that if you sue in a court that's other than the place that is labeled in the forum selection clause, the proper way to vindicate that is a motion to dismiss under 12B3, improper venue. And the Supreme Court, in an opinion, says 9-0, I believe. That's crazy. Private parties, the venue of federal courts is determined by federal statutes. Parties can't create venue. Parties can't destroy venue. And I would sort of think that the defenses available in a Title VII action are the defenses that Congress creates for a Title VII action. And they did. The defense in a Title VII action is you have to go to the EOC within 180 or 300 days, and then you have to sue within 90 days. And if you don't do that, then you have a defense. But we all agree that defense is not available to you here because they didn't violate that. So it's as if the parties by contract created a new defense to a Title VII action. And I just think that in almost no area of law would we let someone do that.
I understand that concern. I do. But there's also this other concern, and I'll tie it back to the arbitration
Okay?
discussion if we can. Why is it that a party, if arbitration is the distinction, if you say you can limit the statute of limitations so long as you say you're going to forego the EEOC process and submit these cases to arbitration?
Because the Federal Arbitration Act says you can agree to arbitrate claims.
Sure.
And Congress encourages it.
Agreed, right? Why shouldn't it be any different here? And I guess my point is, just because there is a shortened of the limitations period, I can understand how, if Logan was in front of you today and not this limitations period in front of you, I can understand how it would seem unreasonable to prevent a party from seeking an EEOC investigation through that agreement. But here, all this limitations period is intending on doing is, yes, shortening the limitations period, but also telling the plaintiff that if it acts and does so quickly, that claim will be preserved from the moment it is filed.
Yeah, but it still messes with, I mean, I take your point about the tolling provision. It's hard for me to imagine how Logan could have come out differently given the lack of a tolling provision. But even if you have a tolling provision, it does mess up what Congress put in place. And I was trying, really, my law clerk was trying to help me think this through. You know, you're supposed to have at least 90 days before you have to go to the EEOC. And if you shorten that, say this plaintiff decides to split the difference, so now it's only 45 days. Like, the EEOC isn't getting the benefit of the same amount of kind of spade work that the plaintiff's supposed to do before they go to the EEOC. And then at the back end, the plaintiff has less time to kind of metabolize what the EEOC investigation has turned up and get that into a decent complaint. Like, Congress picked these time limits presumably with some care because they thought those were the time limits that would give the fullest effect to the EEOC process. At the front end, the plaintiff has at least 90 days to do the work, and at the back end, at least, or 180 days, and at the back end, at least 90 days to take the results of that investigation and turn it into a complaint. And now you're just making everyone do less good work because they have to rush it through.
The rushing part at the EEOC, and I know that's not the most articulate way to say that, but the rushing part at the EEOC, the idea, the intention of this agreement was to allow that process to unfold so long as the plaintiff seeks the EEOC's assistance in a specific time frame.
Earlier than it would otherwise be, he would otherwise
Understood.
be required to. Right, but,
In this deferral state, Your Honor.
well, even in a non-referral state, right? Because don't you normally have 180 days to go to the EEOC?
Yes,
Right, and so
yes.
obviously the
So-
plaintiff can't do that.
Of course, in theory, you could wait, excuse me, you could wait the 180 days, and under our agreement, if it's 180 days limitations period, you would have exhausted all those 180 days. I understand
Right,
that.
so that would
I
not
understand
work.
that.
Okay.
Of course. The problem too
Can I
here is.
just ask you, this is just kind of,
Please.
I really am trying to figure out how this would work. If you were advising a potential plaintiff, how would you tell them to kind of split the time, the 180 days they've been given? Would you say, like, I mean, what do you think would be the most effective way for a plaintiff to use those 180 days? Where should they take it from, the front end or the back end?
If I were a plaintiff,
Mhm.
I would take it from, I almost said front, and now I'm wavering to back,
See,
and now
it's
I'm
hard,
wavering to
right?
front. It is difficult. It is a difficult thing to conceptualize
Sure
and think
is.
about. But I would do this. I would file as soon as I could with the EEOC and allow that process to unfold. While that EEOC process is unfolding, I would engage my attorney to prepare a complaint, a civil complaint.
But what if the EEOC is going to sue for you? That's a lot of money, or, I mean, why should you have to hire a lawyer when the EEOC hasn't decided whether it's going to sue?
Fair, which is why I would do it as soon as possible. I would file my action with the EEOC, the charge of discrimination, as soon as possible.
Do you have any idea what percentage of people who file charges with the EEOC have lawyers when they file those charges?
I do not, Your Honor, but I'm
Would it
sure it's a
surprise you to
very
know
low percentage.
A very
Of
small
course.
number of them?
Of course. And that's also the purpose of Title VII, right? We're trying to ensure that if a discrimination case arises, those with the least means or those with unavailable means are able to access the EEOC's system.
So can I go back to that 250-day hypo?
Yeah.
So we all agree that, assuming for the sake of argument that this provision is binding on the individual, it is in no way binding on EEOC, right?
The limitations agreement?
Yeah.
No, it is not binding on
So in
the
other
EEOC.
words, if a person who signed this agreement filed with EEOC on day 250 and EEOC sues you, you have no argument whatsoever.
Agreed.
So that then means that for that category of plaintiffs, whether EEOC chooses to bring its own action actually dictates not just whether it's EEOC or the private plaintiff, it dictates whether there'll be an action at all. Because in that situation, the plaintiff, the individual, has, you know what I'm saying? Like normally all that's really at stake for EEOC is like, are we gonna bring this lawsuit or are they gonna bring this lawsuit? But in that situation, it's not, are we gonna bring this lawsuit or are they gonna bring this lawsuit? It would be, are we gonna bring this lawsuit or is this lawsuit dead, right?
Potentially, yes.
Which potentially puts the EEOC people in a different position of saying, like, it's one thing to say, like, resource constraints, you know, right? So I'm not going to bring this lawsuit, but she seems to have a really good lawyer. She'll bring a private party suit. That'll vindicate the purpose of the statute. But, oh, no, this one has, like, it just seems like this is another way in which it could screw up the EEOC's enforcement decisions of the knowledge that, oh, in this particular set of circumstances, we have to bring this lawsuit or there will be no lawsuit. And that could start to skew EEOC's incentives in all kinds of ways.
I see where you're going, and I would agree with you that there is a potential there. I agree.
But isn't that yet another suggestion that it would really screw up what Congress did here to let you do this?
No,
Okay, why not?
and here's why. And this goes back to your question, Judge Harris. I'm going to try and tie them together as best as I can, okay? I would file quickly. I would file within 30 days or 60 days, my charge with the EEOC. That tolling provision allows the EEOC to take its time with the investigation. It further allows the EEOC, if it's a 300-day jurisdiction case, to take as much time as it needs. It then allows that 90 days for the right to sue to unfold, well within the 180-day period that we've done.
You know, this is, I guess I find it striking because earlier you said this is difficult. It is difficult, and when she asked the question about what advice you would give your client, we're talking about someone who has to sign an employment agreement in order to be employed, correct?
Yes, but may I say yes,
But they don't sign the employment agreement that you have, they don't get the job, right?
Potentially, they could negotiate it, right? This is we did not litigate that issue here. No one has alleged it's a contract of adhesion, for example.
But I
Your Honor.
guess what I'm saying is, if it is difficult for someone who is an attorney, as you've stated here today, that this whole process is difficult, how is that not difficult for someone who is unsophisticated in the process of signing an employment agreement as to knowing that they have to file something with the EEOC immediately, although they have time to do it, and then, and I think what Judge Hytens alluded to is that most people don't have an attorney. How is any of that reasonable?
It's reasonable in that if you are going to sign an employment agreement and be employed with a company, you too need to read those agreements. And that may seem harsh, okay? And I can understand that. But the employee needs to understand his or her rights with respect to their employment.
I really
Okay.
worry that even if, so posit a plaintiff who remembers that they signed this 180-day agreement, once they get the letter from the EEOC saying you have 90 days to sue, I mean, I would find that very confusing as a lawyer. Like, maybe the EEOC has made a judgment, like, those things aren't enforceable, great, I have 90 days to sue. I mean, I just wonder if you were right, doesn't the EEOC need to modify its letters?
Well, I was going to say this, and I'm not sure that, well, yes, to answer your question, Your Honor, yes, perhaps it would need to modify its letters. And maybe it is just a simple standard form, they only
Wouldn't
say
that
it's
go
90 days.
against the intent of Congress statutorily? Now it's because of your provision in your contract, now we're telling the EEOC that they need to change what Congress has told them to do in their letter to comply with your provision in your contract.
I get the tension there, and forgive me if I'm speaking too broadly, but I'd like to say it this way. These contractual limitations periods, okay, in this circuit have been enforced. They have been enforced since the Atlantic Line case, perhaps even before then. The tolling here is an important aspect of the statute because it preserves the EEOC's power to investigate. So long as the plaintiff files her claims timely within the 180-day period. The limitations period, although shortened, there's still a limitations period within Title VII, right?
Let me ask you this, and I realize you're almost out of town. So how do you reconcile in Logan, and I know Logan is a Sixth Circuit, but how do you reconcile Logan's reliance on the Supreme Court case Davis, and also I think the other case was Brooklyn Bank or something like that, where the Supreme Court is saying that this is a subject where this language is, limitations period is intertwined with, I think that's Davis, or if set out by Congress, then it's a substantive right. And then you have Brooklyn, I think it's Brooklyn Bank, or it comes back where they say you cannot waive that substantive right.
I think the substantive versus procedural distinction here is a complicated one, to be sure. I don't know that this circuit has specifically addressed it, at least in this context. In Roy Cotton Yard did, in the antitrust context, Your Honor, of course. The procedural versus substantive distinction often depends on, of course, if, let me put it this way, of course, if the substance of Title VII is to ensure that a person's rights with respect to discrimination, and I know I'm out of time, Your Honor, and I'm trying to finish the
Yeah, of
question.
course.
With respect to discrimination claims are preserved, right? But the limitations period, I don't know that it is substantive. And I think what we've talked about.
Can I just ask, sorry,
Yeah.
what do I do with the fact that statutes of limitations are substantive for Erie purposes?
What do we do with the fact
In
that?
diversity cases, statutes of limitations are substantive for Erie purposes. As in, if you're suing on a state law cause of action, the statute of limitations comes from state law, not from federal law. That's SIBAC that says that. It seems hard to square with some of this notion that these are procedural, because literally in deciding whether federal law or state law governs, where the rough allocation is, if procedural federal, if substantive state, the Supreme Court has said statute of limitations are governed by state law. That suggests they're substantive.
To be honest with you, Your Honor, I've not given that any thought.
No
prior to
problem.
Today, okay? So I'm not gonna sit here and pretend like I have some eloquent
I
answers for
appreciate
you
the
there.
candor.
I do not.
Okay.
But if I
Then
can,
you-
Judge
go.
Benjamin, if I can, just to piggyback very quickly, and I know I'm running out of time here. The Title VII charge filing instruction, and I think this gets to the point here, is not jurisdictional. And that is a case from 2019. It's a Supreme Court decision, Fort Bend County. That was referenced in Bracey. The fact that it's not jurisdictional to file this charge lends also to the idea that limiting the limitations period is not a jurisdictional thing either. And that, to me, gets to the substance and procedural distinction.
But then
Bracey-
on the procedural, you would agree that the arbitration provision, well, let me say, you may not agree but with me, but it seems to be procedural. It's procedural as to what form we're gonna be in. It's not, it doesn't deal with the exhaustion of the remedy. It just says you're gonna handle it in arbitration, in Emory Court.
I understand that. I would agree with
Which,
you. Yeah.
which seems to me to be procedural, whereas this seems to be more substantive, and I had not thought about what Judge Heitens has stated, but that may, if you think about it, I guess in terms of statute of limitations, then it would be substantive.
I'll give you one more cite that I think may help with the substance versus procedural distinction. That is Abelar versus IBM. And it cites 14 Penn Plaza, which is a U.S. Supreme Court decision, 556 U.S. at 265 through 268. And Abelar and the Supreme Court decision essentially talked about how the ability to file suit is procedural, not substantive. And the tolling provision here, the limitations agreement, merely focuses on that ability, the ability to file the suit. With that, Your Honor, I'm well over my time, forgive me. We simply request that the court affirm the district court's decision in all respects. Thank you very much for the privilege and honor.
Thank you. Thank you. And Mr. Santo, yeah, you've got a little rebuttal time.
I'll address directly that there's a difference between jurisdictional questions and whether or not something is substantive. And I think that that's important here. Jurisdiction really just determines whether or not the court can even make a ruling one way or another, and that is, a question of jurisdiction is not waivable. If the court has no jurisdiction to hear the case, then no matter what decision came down, if the district court had said, you know, we agree with the
And the
plaintiff.
inverse is true too. If a court doesn't have jurisdiction, the parties can't create it by contract, right?
Correct.
The court either has jurisdiction or it doesn't, irrespective of what the parties agree to.
Correct, and that often comes up, I think, a lot of times in reviewing, for example, settlement agreements. If there's a breach of a settlement agreement, that tends to be a breach of contract, so even if the claims released were federal claims, that would be a state law issue. In a lot of cases, the district courts don't have jurisdiction to review those claims.
Can I ask you what you think turns on whether this is a substantive, whether the statute of limitations here is a substantive right or not, because sometimes I feel that people shorthand this to if it's substantive, it can't be waived. But I thought the law was, if it's substantive, it can't be waived if waiving it would be contrary to the public policy behind the substantive right. Which formulation do you think is correct?
I think there is an aspect that the substantive waiver can exist. In most cases, we're dealing with after the fact. When we're dealing with the substantive waiver, it deals with, for example, no prospective waiver of ADEA timeliness claims, like, or other substantive
But
rights.
even a plaintiff who has a 100% valid Title VII claim can, after the fact, waive it by saying, I agree to release my claim against you for $1 or nothing, right? You can do that.
And that would occur after the
Right,
claim
but-
has arisen.
Right.
And I think that that's the important part, is that this employment agreement was signed prospectively before any claim was arisen. So the substantive right here is that, yes, you can waive the substantive right after the claim has arisen, but not prospectively before the claim, before even getting into employment. You're agreeing with your employer, I will give up my right to have the full 300 days before you even employed me, before you've even had the chance to discriminate against me. And that's the policy issue here. And I do want to point, and I know it's dicta.
So I'm sorry, I really would like to just try to nail this down. So the rule you are proposing is a substantive right cannot be waived until what happens?
Until the cause of action is accrued. And
And
I'll,
I'm sorry, and that would be whether or not that would be contrary to public policy. Like, there's no kind of proviso that the waiver has to be contrary to public policy.
so I would argue, Your Honor, if the waiver is contrary to public policy, since waiver essentially is an issue of contract law, any violation of public policy is something that would make the contract void. Because once you're getting to waiver, you're
Yeah,
dealing with
yeah,
an
I shouldn't have
agreement
said
between two
public
parties.
policy. There's a bunch of
Congressional
cases-
intent, Your Honor, perhaps?
Yeah, the legislative policy behind the substantive right.
So
You wouldn't ask about that. You would just say, look, if it's substantive, you can't waive it until the cause of action accrues.
Correct.
Okay, I'm not finding that in the law, but I will look again.
That would be my argument, at least with regards to the intent of
And the way
Title
we would
VII.
distinguish all the arbitration cases is saying, in that situation, it's about the need to reconcile two federal statutes, Title VII and the federal. So Gilmer is about the need to reconcile Title VII or whatever employment discrimination statute was at issue in Gilmer, it might have been the ADA, between that statute and the Federal Arbitration Act. And what the Supreme Court says, well, in that situation, we resolve it in saying you can arbitrate those claims, right? That's how you'd wall off all the arbitration cases?
I would actually argue, Your Honor, that the timeliness issue and whether or not a case can be heard in arbitration is actually two separate issues. The cases that were addressed in this matter that dealt with arbitration agreements, based on the arbitration agreement, there was no requirement to go to the administrative agency in the first place.
But there was a requirement to go to the arbitrator on a shorter time frame than there would have been an obligation to go to court in some of them. Cotton yarn, that's the fact situation in cotton yarn, for
Well,
example.
and in cotton yarn, though, again, we're dealing with different statutes. That doesn't deal with Title VII, ADEA. It deals with the Sherman Act. We're not dealing with the anti-discrimination statutes.
Sure, but obviously the antitrust laws create substantive rights, right?
I would agree, but I want to point, because I know I'm running short on time, that there's language with regards to congressional intent in Zipes versus TWA in addressing the amendments to Title VII and in adjustments with regards to the timeliness. And it's on pages 394 to 395 of the opinion. The subsection as amended provides that charges be filed within 180 days of the alleged unlawful employment practice. Court decisions under the present law have shown an inclination to interpret this time limitation so as to give the aggrieved person the maximum benefit of the law. It is not intended that such court decisions about that be in any way circumscribed by the extension of the time limits. Congress, when discussing and extending time limitations, discusses that any discussion about time limits with Title VII is to give the maximum benefit of the law to the aggrieved individual. And I know that my time has expired, subject to any questions, Your Honor.
All right, thank you very much. We will come down and re-counsel, and then I'll ask the clerk to adjourn us for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this